following program is classified G. It's suitable for all ages.
Tonight, we take a look at the discussion on the capital punishment. Sri Lanka has not implemented the death penalty since 1976. However, the capital punishment is provided as a penalty for convicts involved in the most heinous of crimes. Recently, prisoners had protested the implementation of the death sentence and pushed for the sentence to be reduced to life imprisonment. As a sovereign nation, Sri Lanka is entitled to implement laws that it deems fit, even when it comes to capital punishment, regardless of the pressures of the international community. Moral questions are raised as to whether the death penalty is suitable as a punishment for the 21st century. Welcome to Law, Land and Liberty, where we take you across a weekly topic. And this time we have selected the death sentence, the capital punishment, and how it's functioning within the country. And for that we have invited an individual that has been within the public forum, that has been within the legal community for a while, has discussed, has represented people for a long time, would give us a lot of experience pertaining to this matter. President's Counsel, Tirantha, Walaliyadda, thank you so much, sir, for joining us. Thank you for giving time during this day. Sir, before we go in, I need to give our audience a bit of a breakdown as to how we are going to approach this topic. We're going to talk about the provisions for the death penalty first, then talk about the implementation and the grounds of appeal when it comes to Sri Lanka, then life imprisonment and how it differs to the death penalty, and finally, as an international figure, how Sri Lankan functions in the global platform.
Hi, my name is Sri Lankan and I am a law student. My question is about the provisions for the death penalty. What are the provisions within the Sri Lankan law for the death penalty?
All right, let's get into the discussions. President's Counsel, Tirantha, Walaliyadda, sir. Our first question is going to be on the provisions for the death penalty, and to give a breakdown initially, just to give like sort of context to this discussion, what the law states and where the death penalty can be used and where it's life imprisonment, and we'll talk about limitations and thereon. Where does it say that the death penalty can be used within Sri Lanka, sir?
Firstly, in the Penal Code, section 296, that is murder. That's interesting. Shall be sentenced to, there is no alternative, there is no option, right? Other one is drugs, drug trafficking. Can be sent, you shall be sentenced to death or life, one of the two, right? And then I think in the firearms ordinance, again, automatic firearms, you can get a death sentence, right? Those are the three areas of sentencing. Where murder is concerned, the Penal Code, there is no option. Where the drug trafficking is concerned also, shall be sentenced to death, right? The other one is the firearms. So those are the three main areas of the death sentence. But problem here is not the provision, the activation of it. That is the problem here. Mm-hmm. There are enough of death sentences that you can find. The question is whether it will be activated.
All right. Well, if you could break it, going further, is there any other legislature that affects the death sentence? Like,
no.
Apart from this, the Constitution, or is there something that was used by parliamentarians to amend or to remove the death penalty in recent history? How has that worked?
That is to make the international community happy, no, right? From I think the last person to be hanged was in 1976. After that, not a single person was really executed. And of course, the people who committed death penalty crimes had a gala time. Because they knew that they are not going to get hanged. That is why this country, this society, came to this most deplorable situation. But for some reason or the other, which I can't understand, right? The law was not implemented, maybe due to various, the law is clear, no?
The law states that the death penalty is allowed within Sri Lanka.
Not allowed, it is mandatory. Right? If you kill somebody, you hang. If you murder somebody, if the ingredients of the offense are complete and proved, You are sentenced to death. The next step is to go for the appeal. Then the president will, what he says is that at a time and date and place appointed by the president, you will be hanged by the neck until you are dead. So you come up to that point, waste years and years of time, waste millions and millions of rupees up to the death sentence that is given, and then we waste millions and millions of rupees looking after the man inside the jail.
That is how it's functioning.
That is how it's functioning, and the people know it.
I want to question you on something you mentioned there, on the process of crime. Once the elements of crime are fulfilled, that is what you said. How does that process work? Now, many people, does a lower court, my first question, does a lower court have the capacity to give this sentence? Just for the clarification of the laymen that are watching the program. Is it only a higher court that can give this? And how does that appeal process work? If we can talk about the appeal process actually within our next segment, but firstly, how does the process of law work?
The process of criminal law, it all starts in the magistrate's court, right? If it is a murder case, now we're talking about the sentences now, then there is something called an unsummary procedure. There you take the evidence available and then forward it to the Attorney General. Attorney General goes to it, and if he sees there is a fit case to be tried, it is sent to trial to the High Court. The magistrate court does the preliminary inquiries, right? Records the evidence, sends the brief to the Attorney General. Attorney General goes to it and sees whether there is a case to answer. If he is satisfied, he will send it to the High Court for trial. The magistrate court is not a trial, right? The High Court will then take in the evidence available, subject to cross-examination, subject to all the restrictions and permissive things that are in the evidence ordinance, and go into all that and assess the evidence. And on the evidence, the High Court will decide whether there was the intention to kill, whether there was a knowledge that this will cause death, and then accordingly convict him if the evidence is satisfactory. And then the sentence must be given. Then the sentence is given. The High Court has given the sentence. Then the matter goes into appeal. And remember one thing, in a death sentence case, the High Court cannot entertain a plea for guilt.
Could you explain that?
The accused can't say in a death sentence case, supposing you say you're charged with the murder of X, right? If he says I'm guilty, it is not recorded. It is recorded as not guilty.
Okay.
And the whole thing goes to trial on the basis that he is not guilty. Right? That is one of the checks that are given, because we don't know why he's pleading guilty, no? Right? Then at the end of the trial, the High Court judge will decide, or the trial bar will decide, whether the evidence is sufficient to convict the man. Right? And if he is convicted, the sentence is given, then the appeal is filed in the Court of Appeal. Right? If it's a trial bar, it's in the Supreme Court. Those higher courts will decide whether the trial is legally held, the evidence are legally admitted, and the evidence is sufficient to uphold the conviction. If they uphold the conviction, they will affirm the conviction and affirm the sentence also. Then the whole thing goes to the president. It is up to him to implement.
Sentencing part of it. My multiple questions come up actually when you make that explanation. Just to clarify, actually, we can really use this time. Now, if there is an individual who wants to appeal from High Court to a court above and does not have the monetary capacity to do so, does the state allocate a lawyer to that person? Or how does that appeal work for someone who wants to appeal above the higher court?
If a person has no monetary capacity even in the High Court, the state will assign a counsel at state expense.
To any appeal, even to Supreme Court?
Anything, even to Supreme Court, they will assign a counsel. In the High Court, they will assign a counsel, and he will do his best to, on behalf of the accused. Then he goes to appeal. And when the appeal is called up, the justice of the Court of Appeal asks, do you have anybody representative? If he says no, he asks him, do you want the state to appoint? If he says yes, then the state counsel present will nominate a counsel in the unofficial bar. He'll be assigned to the case, free of charge, that is paid by the state. So there is no question of saying I have no money to do the appeal. Right?
Just to get a clarification on our first segment itself, the High Court is the first place where the death sentence could be applied. In your experience, does it stop there? Has it ever stopped there? Or does it always go above to the appeal courts?
No, the death sentence, there is, I think, there is an automatic appeal to the Court of Appeal.
Okay, all right.
It's automatic. Right?
Okay.
And then the Court of Appeal decide whether the trial was legally held. And then, if that fails, of course, the case can go to Supreme Court.
Okay. A very good context provided. I really want to continue this line of thought. We'll take a very short break, sir, and we'll come back. You're on Law, Land and Liberty. Stay with us as we delve deeper into how the death penalty functions within Sri Lanka.
Hi, my name is Tirantha. I'm a computer science student, and my question is about the implementation and grounds of appeal. How is the death penalty going to be implemented in Sri Lanka?
Welcome back to Law, Land and Liberty. We are going to talk about implementation now, and we're going to continue the discussion on the grounds of appeal. I think we made a good segue into how appeal works. I will just finish off that discussion, sir. I want to get this clarification from you now. You mentioned the Court of Appeal and Supreme Court, their primary role is to see whether the case worked properly within the previous courts. What does that exactly mean? What are the grounds of appeal, if I may ask? Like where I believe if there is new evidence that comes up, then the case changes a bit. Apart from that, if you could give us those two methods, what are the grounds of appeal?
It is very, very rarely that you can bring in new evidence into the Court of Appeal. The Court of Appeal will work within the framework of the High Court brief. It's very rarely that they will permit some fresh evidence to come in. Very rarely, but that has been done. But very, very rarely, right? They go to within the framework of the brief, and they will see whether the trial was legally held, whether inadmissible evidence has been admitted, whether bad character evidence has gone, whether the procedural aspects were observed, and so on and so forth. They don't go into they don't retry the case. They will see whether the High Court has attended to the matter in proper legal form. They are going to the legality of the trial. It is only in a rare case that they will go into the facts of the case and say, well, on these facts we can't confirm this appeal. We can't affirm it, very rarely.
Even if there's new evidence, are you saying that there will be no retrial? Is it how?
But generally, you must give good reason why the new evidence that you propose to give could not be led at the original court. It must surface subsequently, and must be of vital importance that hits at the core of the prosecution's case or the prosecution's case. If it is available at the High Court stage, and you are going to sleep on that, you are not permitted to do it in the Court of Appeal because there is never-ending. The system must stop at some point, no? Yeah. So if the evidence surfaced subsequent to the conviction and it hits at the bottom of the case, then the Court of Appeal should permit.
Who makes that call? Is there a separate hearing for whether the evidence is submissible, whether the evidence should be taken in, or does it come under the appeal?
During the appeal. Probably by an affidavit.
Okay.
And with connecting documents. And say maybe videos or whatever, that has surfaced suddenly, showing that somebody has done the murder. Maybe it's on a camera. Somebody doing the shooting. It has suddenly come to surface. And in such an instance, the Court of Appeal in all probability permit that, because you see at the end of the day what the Court of Appeal wants to do is not to affirm or disaffirm the conviction, but to do what is correct, no? You want to get the correct man. So it's blatantly obvious that somebody has done the shooting. They will permit that evidence to come in. It's a very serious application, not to be taken lightly.
The reason why these questions I'm portraying is we work under the fundamental principle that everyone is innocent till proven guilty. I believe that is also how it functions when it comes to these cases. Now I want to take a step further and talk about, since we're in the topic of implementation, and you mentioned 3 grounds where the death sentence is in fact put into motion. And you said drugs. Now, one question that I have, I'm not sure if possible, just give us a clarification on this. If not, we can move forward. Is there an amount or this amount of drugs being found with this individual?
2 grams and above.
2 grams and above, and that
attracts the death sentence.
Would be provided the death sentence.
Possession of 2 grams and above attract death sentence. Trafficking is a different story. Trafficking where you go and distribute the stuff.
Exactly.
You are sentenced to death anyway for that. Trafficking, because what happens is You know, we find some ridiculous situations. They go and catch hold of somebody and charge him for trafficking. And they found 2 grams of heroin in his pocket. You can't traffic 2 grams of heroin, though. So, but then when you put trafficking, the bail is very difficult to get. When you put trafficking, you go to the Court of Appeal to get bail, to the High Court to get bail, not in the Magistrates Court. That is why the police generally put trafficking. Even if there is evidence or not, they put trafficking, you know. And subsequently they will say, we'll get some evidence and come. But why they put trafficking is because it is very difficult to get bail. You have to go to the High Court.
That's a very good point. I think I just want to get clarification on that, on getting bail and how this accusation works, because when 2 grams, let's say, is found on an individual, he's not immediately sentenced to death. There is some investigative process. He will be arrested. I believe if you can give us a clarification on how that works, like will they be arrested without any questions asked? Is there some investigation process, or to which period can they be kept under arrest? How does that work? If there is 2 grams found on a person.
That is what confuses me also. You know what I mean?
Is the law not clear on that?
The law is very clear. The investigations are not very clear. You know why? Now we find TV, we find on your channels. One chap is found it, 1,000 kilograms of heroin, packets and packets of heroin. You know what I mean? Room full. They catch him with it. Okay. And then investigations continue. There is no indictment coming in. There is no investigation, don't finish. They say they have to catch X, Y, and Z, and they are going to Arabia, Saudi Arabia, this man with the heroin stuff, which they say was found with him, he is happy to stay in the jail. And in the meantime, they will file a Court of Appeal, an application of bail. And at some point, I think he has to be granted bail, no? You can't keep them forever, no? Right? So to my mind, if you catch this type of quantity of heroin, with the man, or shall we say, there was one day they found it in the dicky, you know, where the man was driving, in the boot of the car. It's just a question of taking a little bit of that heroin and sending it to the analyst. Analyst said, this is heroin, right? And you indict him, and you hang him. What is the problem here? Why is the delay here? The problem is the delay, you see. And I don't see any reason for the delay in this type of detection, caught red-handed, according to what they say. I'm going on the news broadcast, right? Because you can only know from the news, no? Right? People are found with package of heroin in their lunch packets, right? But they are not, the investigation takes more than 1 or 2 years. When you ask them, they say, we are trying to locate the top man. The top man can be located later on, right? But this fellow can be prosecuted, no? Why don't they file? If they file the charges immediately, you know, there's a big, and then the trial is over. It's not a big problem to have a trial, no, if the necessary material is there. Here what you need is the heroin, room full of it. The net result, the analyst. Right? And the police officer investigated. What is the need?
That is the process that is available.
What is the problem? They say they are looking for somebody in Saudi Arabia. They can look for the man, but they can also convict this fellow, no? I mean, connecting the matter for the court. They can file action against this person, but the investigation is not being completed. The file does not reach the Attorney General. This is the problem. The file does not reach the Attorney General.
If you could explain that process between the magistrate courts and the High Court, where you mentioned that it goes to the Attorney General. If a state counsellor is representing the person who's been told that he was the one who did the crime, who's accused, is the state representing both parties in that scenario? How does
state counsel doesn't represent the suspect.
It's a private.
State counsel represents the state, that is the prosecution. He will never represent the suspect in a criminal case. That is done by private counsel. That is done by us. Right? The state represents the prosecution.
So even if it's pro bono, if the person can,
you don't have to pay. No, the state.
The state will be paying the.
The state is they are officers of the state. No.
Yeah.
It is the defense that has to be paid. The lawyers there,
yeah.
if at all, right? So the expense is at that point. The prosecution has nothing to worry about because the state is there and they are doing their job, no? They are state officers, they are prosecutors, they prosecute.
As a final question for this, because we are talking about implementation, and I think you're very clear in the issues that you have seen within the process. What is the general time period like from magistrate courts to high courts to court of appeal to Supreme Court to then being, without an appeal being sentenced? First question, what is the average time frame of, like, in your experience, what is the time frame like? And secondly, what are the cases that are the kind of quantity that is available already outside that is not being convicted? What is it a large number, or is this process too long? What is the time period, right? Basically, a time period.
I didn't get what you're saying.
My basic question is, from magistrate courts to Supreme Court, this entire process, if someone keeps appealing, let's just start with the first question. What is the rough time period for that entire process?
If the police file their final report, right, on a drug heist or a haul, right, they can do it within 2-3 months. Especially when they catch hold of tons and tons of heroin. What is the big problem there? You know what I mean?
That is the filing the report.
Filing the report. You see, you first of all bring the suspect to court with a B report and say, this man is suspected of trafficking in such amount of heroin, right? And then they will say that they are going to send the stuff to the analyst, right? And then man is remanded. No? Every 2 weeks the case is called because he is on remand. Every 2 weeks the police must put a fresh report and inform court of the progress in the inquiry, right? Every 2 weeks, okay, 14 days. And then at some point of time, they have to put what is called the final report. Right? Investigations are over, you are sending it to the Attorney General. Problem is, to get to the final report, it takes years, which I can't understand why. You see? There are special units for this drug business, drug detections. So I can't understand why, especially this type. You see, what I'm trying to say is this. Okay, the little grams or 2 grams, 3 grams, the analyst must be getting, you full up with all sorts of. Now, I'm going on the basis of this, not on the basis of the corona thing, right? This COVID thing. It seems that there is no COVID affair. The same thing happened. Of course, the analyst will say, I'm overworked. Right? That is because of the corona, the COVID affair. But at that time, before this whole thing started, the analyst has to file his report. So he generally didn't very much delay. If he delays, it is up to the defense counsel to inform court there is a delay in this report. Why don't you call for the report? Then the magistrate will call for the report. Then the analyst will send it. So if the defense also just hangs around waiting, well, okay, fine, another date, the case will never be over. The police will start investigating something else. And then at the end of the final reports will be investigation continuing, not a single thing is done, just one line.
There's a delay.
So finally, when somebody goes and creates a big fuss in the magistrate's court, they file a final report.
Right.
That is the delay is at the investigation stage. Then it goes to the Attorney General, right? So depending on the workload of the Attorney General, and I must say the Attorney General is definitely overworked, right? And they are recruiting staff, right? And then also the Attorney General finds that there are certain loopholes, gaps and this and that are not being filled by the police, so they have to send it back again. So there's a bit of a delay there, right? But they will send it to the High Court. So once it goes to the High Court, indictment is filed in the High Court will register it and give it a case number. And they will issue notice on the suspect, on the accused, wherever either is on bail or is on remand, right? And then normally, before this kalabola started, right, normally in 1 month or so, the man is produced from remand or he is asked to come. He comes, right? Then the indictment is served, right? Indictment is served, okay? Then it is fixed for trial. That should be depending on the role of the court. Depending on the role of the court, if that is, they will fix it at the earliest possible opportunity, maybe in 2 months' time, fix for trial, right? So then at the trials, when the matter is called for trial, the accused says, are you guilty or not guilty? He will say not guilty. At the initial stage of this, ask whether he is guilty or not guilty, right? So generally you can't say you're guilty to indictment that you have not seen, no? So generally it goes for the trial. You again, are you guilty or not guilty? We say not guilty. And the trial will commence. Then the prosecution will start calling its evidence, right? And then the cross-examination will start and it will take its process. You see, the problem here is, the question is, if the trials are held day to day, right? Within 1 week you can finish a case. The problem is the courts are so, the court's trial roll includes about 6 trials for a day, part-heard matters. Part-heard matters. So they will take half of the evidence today and put the cross-examination for the next day. Then they will take the next case. And then they will take the cross-examination for that case and put the next witness to the next day. So then the delay is at that point. When it comes to court procedure, delay is at that point. If the courts can take up the cases day to day, say from 10 to 4 or 23 or whatever, I think within 1 week you can definitely finish our drug case.
All right.
Depending, of course, on the defense must cooperate.
Exactly.
Without just wasting time and asking unnecessary rubbish. You know what I mean?
Yeah. I think you have ironed out a lot of the reality on the ground. It's very important for most people, as like everyone, to understand, because people blame a lot of stakeholders but are not aware of what's happening, and I think it's very good that you explained all of that. We have to go for a small break, but before that, here is our very own Anuradha Wickramasinghe, who is going to bring our new segment where we talk about the daily happenings within this week, within the legal society, within the legal atmosphere within this country. Here's Anuradha Wickramasinghe with Law in the Land.
Thank you, Danidu. This too has been an eventful week in the legal field. Let's take a look as to how the law has worked in our land. The Chief Justice has appointed a special 3-bench trial at bar at the Colombo High Court to hear the case against former Defence Secretary Hemasiri Fernando and former IGP Pujit Jayasundara on negligence of duties and failure to prevent the Easter Sunday attacks. The cases were filed by the Attorney General, and the trial at bar will be chaired by High Court Judge Namal Balale. In May, the Attorney General exhibited information in the Colombo High Court consisting of 800 charges against Jayasundara and Fernando in respect of those killed and injured in the Easter Sunday attacks. Supreme Court Judge Mahinda Samewardana recused himself from hearing 2 fundamental rights petitions filed by former Minister Rishad Badiuddin and his brother Riyaj Badiuddin, challenging their arrest and detention in connection with the Easter Sunday terror attacks, citing personal reasons. Justice Samewardana is the 4th Supreme Court judge to refrain from hearing these 2 petitions. Justice Yasantha Kodagoda, Justice A.H.M.D. Nawaz and Justice Janak De Silva had earlier recused themselves from hearing these petitions. The Court of Appeal has ordered to dismiss a revision application filed by former Homagama District Judge Sunil Abe Singha, seeking an order to enlarge him on bail. On February of last year, former Homagama District Judge was sentenced to 16 years of rigorous imprisonment by the Colombo High Court for soliciting and accepting a bribe of Rs 300,000 in May of 2013 from a person in the Hanwela area to deliver a favourable verdict in a case that was being heard before his court. Environmental scientist Dr. Ajantha Pereira filed a fundamental rights petition in the Supreme Court, seeking an order to take immediate steps for the prosecution of all those responsible in connection with the Express Pearl disaster. In her petition, Dr. Pereira is seeking an order directing the authorities to set up a restoration and conservation fund for the environmental degradation due to the pollution caused by the Express Pearl vessel. Meanwhile, briefing on the damage to the aquatic life in the aftermath of the Express Pearl container ship sinking, the Attorney General told the Colombo Magistrates Court that at least 176 turtles, 20 dolphins and 4 whales have perished due to the resultant chemical leak. That was a look as to how the major events of the law has worked in our land. We will now go in for a short commercial break. Join Danidu on Law, Land and Liberty on its next segment shortly after.
My name is Isri Chandrasiri and I am an economics and management student. My question is about life imprisonment. What are the important differences between life imprisonment and the death sentence?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Tirantha Walaliyadda, sir. My next question is going to be on life imprisonment now. this might be, since for a person like you who have been in the legal community for a long time, this will be possibly one of the easiest questions for you to answer, but many people on the ground, laymen, would not know the differences between life imprisonment, death penalty. Isn't that the same thing? What is the big difference? Where I think you explained very well the crimes that involve with the death penalty. If we can go a step forward, sir, because there were protests, and this has happened before as well. Let's not talk about the reasons behind the protests or anything, but prisoners have asked to reduce the death penalty to the life imprisonment. What is the reason there? What is the logical reasoning behind that? Or is it mere uproar that is created within prisons? Is there a chance to appeal easier when it comes to life imprisonment over the death penalty? Whether are the crimes for life imprisonment drastically different to that of death penalty?
Okay, I'll tell you this way, right? I mean, regard to the current state of affairs, the crime rate in this country, now you see what happens is, when you're in the department, I think it happens now, when there is a death sentence given, right, the State Council prosecuting has to write a report to the Attorney General, right, recommending that death sentence be carried out or it be commuted to life imprisonment.
Okay, so it's the call is made by the State Council.
State Council. The judge, High Court judge, as soon as possible sends it to the Chief Justice, his recommendation, right? The Chief Justice sends the to the Justice Minister. Justice Minister, his recommendation sends it to the President. Then going through all that, the President has the right to commute it to life imprisonment. That is how it works. I don't know how it works now, right? So that as soon as the conviction is entered, you have to, the State Council prosecuting must file his report to the Attorney General recommending that this should be commuted. I am telling you one thing, because in all the cases that I did, right, I recommended the carrying out the death sentence only in 2 cases. All the others, I said no, this has to be commuted to life imprisonment. Right? So that the matter is fresh in your mind, matter is fresh in the mind of the judge, right? And the reports are sent separately. There is no consultation. Yeah, the judge sent it to the Chief Justice, I send it to the Attorney General. The Attorney General takes the whole lot and sends it to the Justice Ministry. And the Justice Ministry will put his recommendation and send it to the President. So the President can have an overview of what has really happened here. That is how it really, that is how it should work.
Right. That is the process
now.
So, in terms of crimes, yeah.
Come again. Now, where this commuting into life imprisonment is concerned, you see, in the context of current affairs, you must divide the 2 types of convicts.
Exactly, that is my question.
One is the general murder, right? Where you get worked up and you stab somebody and you get convicted, unfortunately, for murder, right? Those are most of these things have a reason, some sort of provocation. Right? Most of these cases, there is some sort of provocation, maybe a land dispute, maybe a love affair, maybe some dispute with the next door neighbor, maybe somebody went and, slighted you or something. There is some sort of reason for this, right? You must distinguish those people from the contract killers and the drug traffickers. The contract killers and the drug traffickers must be separated from this bunch of others who generally get worked up and, while having a game of carom or something, they can act somebody. He charged and he convicted for murder, right? Commuting those things is one thing, but my view, I'm telling you one thing, my firm view is now, in the current state of crime, the contract killers, the drug traffickers, there should be no commuting of death sentence, life imprisonment. It should not be able to tolerated. Mm-hmm. I think in the case of drug trafficking, right, and this contract killing, that commuting should be banned. Mm-hmm. They should be hanged. That is my personal, my frank view. After I know this, I have worked with this bunch of people, I have defended them, I appeared for them, right? But taking into account the entire society, if you are convicted of drug trafficking, if you are convicted of contract killing, if you are convicted, if you fail in our defense, then I will say I'll go for the execution. I say, see you.
If you could just portray to us within the law how this difference is made between life imprisonment and death penalty. You mentioned it that it is the council, that the state council that makes that call and suggests that this is the sentence that should be given. Within the constitution or within the penal code, is there a line that says this distinction isn't made?
These are the practice.
It is the practice. So the precedent is set completely by practice.
Yeah, that is this stuff came with the constitution, where the president must call for various things before commuting or before giving pardons or reducing the sentence or setting him free. That is a separate story. This is not that. This is commuting into life imprisonment or death sentence. These are the practice that was followed. I don't know what is followed now.
Okay.
The constitution thing is now. You see, the president must call for reports from all these people, right? But it does not say that the president is bound by those things. And it does not say what the report should contain. Whether it's a recommendation for pardon, whether it's a recommendation for commuting or what it is, it does not say. Just you must call for the reports. So I get the impression that that is just, facts of the case. The president is in a position to see what has really happened here. I think that is all, because you're not bound by any of the reports.
Right. Very interesting line of thought. I'm just to ask as a final question, since you have explained now life imprisonment and death sentence doesn't really have, there's no distinction in the law that says this is life sentence, this is for this is for life imprisonment and this is death capital punishment.
No, there are certain offences which say the sentence may amount to death or life imprisonment. Mm-hmm. You can do either death or life.
Some clarification I want to make is, what is the judge's role here? Does the magistrate judge affirm a state council's decision, or high court judge affirm the state council's call?
No, the state council business is not to go and get the accused convicted. That is what a lot of people don't understand.
Yeah,
the state council business is to present the evidence fairly and call upon the judge, right, to come to his decision. It is not his duty to convict the man. That is all nonsense. His duty is to present the evidence fairly, right, and then call upon the judge, right. It is my view that I have proved the case beyond reasonable doubt. Listen to the defense and take your view and do what you want. That is his position. We are under no duty to get a conviction. That's all nonsense.
All right. I think a very clear distinction has been made pertaining to how the law works when it comes to life imprisonment and death sentence. So we'll go into our last segment next. Since this distinction has been made, we'll take a very short break. We are with Law, Land and Liberty. Stay with us.
Hello, my name is Imad Imran and I am a law student, and today my question is about the international obligations of Sri Lanka. Does Sri Lanka have an international obligation to not implement the death penalty?
Welcome back to Law, Land and Liberty. We are on our last segment and we are in conversation with President's Counsel Tirantha Walaliyadda. So our last segment we are going to talk about the international community, and my question, I know this takes a step back from the general way we do our program. Our general function is to talk about the law, inform the layman what the law is. When it comes to sensitive matters, however, I mean, you are more experienced in this than me, definitely, that international community, even if they know they have a say or even if they don't know they have a say, they tell something. They have some form of opinion on this. The layman would want to know, are we constrained by any resolution or anything pertaining to something like this when it comes to criminal law? You can even mention if there are other types of crimes that we have to follow international norms. Now we have really undertaken the ICCPR, which is sort of like directly what the international community suggested table. We took that and we implemented that within our country. When it comes to the death penalty, are we bound to follow something that is mentioned by the international community?
Not unless we ratify it in Parliament. We are not abolishing the death penalty, no. It's just not being carried out. I don't know why it's not being carried out. It has not been ratified. And you see, the the law or the practical exercise of the law must suit the society that we live in. No? We can't be wondering what's happening in the Netherlands and do what is good for them, no, right? It may be good for them to keep all these murderers happy and, keep them in life imprisonment or whatever, give them whatever situation. But that does not mean it applies here, no. We must, I think Justice Jasanta Kodakoda, the Supreme Court, made a very, very, very valuable judgment. He said in his Lordship said in his recent judgments that Indian provincial judgments like Allahabad, Maharashtra and all sorts of judgments have no design in our law. Most of the time what happens is when you go to the Court of Appeal, somebody comes up with some Indian judgment, right, far below the Supreme Court, and courts that time say this and that, and it's a persuasive value. Justice Kodakar specifically said these judgments have no relevance. The only thing that is relevant is the judgment of the Supreme Court of India. So don't bring this stuff and come. That was a very, very vital judgment, Although it was a big nuisance, all sorts of judgments are coming from the provincial appellate courts, He was very specific in that. He said, no, we will only be guided only by judgments in the Supreme Court. That is all India reports. And that's also only our persuasive value. So you see what he said was that, what his Lordship said was that those judgments are given, those decisions are given in accordance with the social structure, the community, their beliefs, their mode of living, their economic situation. That is how the judgments are delivered. The judgment must fit the society. You understand? That is what he said, what his Lordship said. The judgment must suit the society. So what is suitable to Australia is certainly not suitable for us. So when you are giving a judgment, you must give it according to the social needs of this country. That is at the end of the day the role of the entire legal system, to protect the community. So you can't protect the community by importing foreign ideas into this. It must be given according to the system that we live in.
I have a question though on that line. As persuasive precedents, as persuasive content that is being brought into courts, is there authority that we do follow? Maybe like the United Kingdom or maybe the United States. I think you're very clear when you say it should suit the society. But since these systems, one would say, existed before the law, sort of evolved within our country, should we follow certain systems that are available within other countries?
No, because you see the British culture different.
Are we bound to follow?
No, we are not. No, we are not bound to follow any foreign judgment, right? Because we are a sovereign nation and we have a sovereign constitution. And we are not bound to follow even the Privy Council judgment. We are not bound to follow. It's only persuasive because we are no longer a British colony, right? We are bound only by our Supreme Court, nothing else, and the Constitution, and our Constitution. Nobody else's Constitution. So they can give their judgments, right? But that doesn't mean we must follow them. We can only consider them. If necessary, we can utilize them. There are so many instances where the local Supreme Court has rejected this British judgment, rejected them, said rubbish, So that type of situation, we are a sovereign nation, Nobody can interfere with the judiciary here. You see, what I am trying to say is this, I think I told you, you see, you must remember one thing, right? The entire well-being of the country, of any sovereign nation, right, does not depend on the army or the navy or the police, right, or the parliament. It depends on the judiciary. Right? It depends on the judiciary. Right? So if foreign people start messing around with our judiciary, that will be a big problem for all of us, That must not even be permitted, not even be thought of. Because it is the judiciary that is carrying the entire nation on its shoulders, you know what I mean? If anything happens, where are we going? If there is no judiciary to go to, if you get into a problem, where are you going?
Judiciary.
You only go to the judiciary. There is no other place to go, no? So you know what I have to say. If that happens, so if anything happens, the judiciary and the people will start, taking the bad road.
As a last question, I think you have really shed light on almost every key area that I wanted to question you on. As a last question, since we are in the topic of the international community for the death penalty, one would say the international community has a certain policy against it. In moving forward, will we be pushed towards accepting that sort of role? Will we have to remove it? Will we have to go there as per your observations of how the legal frameworks are working within the international community?
The answer to that is no. It will all depend on these governmental issues. No, this aid, then that aid, then this funding, that funding, etc., etc. If you don't do this, we stop that aid. If you don't do, we stop this aid, and that type of problems the government is facing now. So actually, this is like some international blackmail that is happening here. We are a tiny little country, no, right? And Americans are growling at us. We have to sit up and take notice, no. But what I am saying is this: if we can resist that for 2 years, for 3 years, if we can resist that for 3 years, right, and do the law and implement the law as it stands now, this country will be on a far better footing for recovery in the social structure and this criminal situation than by following these international norms. Because you see, tell me one thing. Now, there's a drug trafficker, right? There's a drug trafficker. Okay, he's peddling drugs to your children, huh? Right? Are you supposed to keep him? Are you supposed to look after him and put him into a jail and spend all our money looking after him? He destroyed your children, right? There is something called, retribution, no? Right? Supposing the drug trafficker comes and destroys the entire school by giving his eyes and all sorts of rubbish. Huh? Are we supposed to look after him, nurture him? If he gets the pimple, go and see what and tell the United Nations, look, he has got a blister somewhere. These people should put against the wall a shot. That is what I am saying. Implement it.
All right.
I hope you put that.
All right. A lot of important thoughts that you have told us. I think you have really
if they are convicted.
If they are convicted. That is.
And another thing I must tell you. If this must go in, right? If they are convicted, right, there should be an automatic appeal to the Court of Appeal, from there to the Supreme Court, and after that the Supreme Court, 5 or 7 bench of the Supreme Court should review the entire case. And then if that bench also decides, then only the matter will be sent to the President to implement the death sentence. And the Constitution must be amended to say that the President shall implement it forthwith. Forthwith. It must be a duty. There is no question now, and the question of pardoning drug traffickers and contract killers should be taken away from the Constitution. Take away that power.
In your opinion, so far it is available. Yeah, that is how
it's available. Even number of drug traffickers can get pardoned. I'm not saying you'll do it, but that provision should be banned.
All right. Thank you, sir, so much for joining us. I think you have taken a lot of time and you have explained a lot of things. It has been an honest pleasure for us to listen to you and get this. A lot of clarifications have been made by you, sir. President's Counsel Tirantha Walaliyadda has joined us on Law, Land and Liberty. Thank you once again for joining us, sir. All right. The debate for the implementation of the death penalty leads to passionate arguments from the proponents and the abolitionists. Amnesty International reports that 483 people were executed in 2020. This was much lower than the numbers witnessed in previous years. In reading up for this program, something I did come across was a famous quote by Archbishop Desmond Tutu. Amongst his many accomplishments was his fight against apartheid in South Africa, which eventually led him to winning the Nobel Peace Prize. He stated once that there is no justice in killing in the name of justice. An important thought for the modern world in debating the death penalty. That is all from us from this week on Law, Land and Liberty. Join us again next week as we break down a legal issue in the eyes of the society. I am Danidithanavasam. Hope you have a great evening.